Gaza. An Inquest into Its Martyrdom. Norman G. Finkelstein. Presented by the Learner's Library. Appendix. Is the occupation legal? Abstract. A broad consensus exists among representative and authoritative bodies that under international law, the Israeli blockade of the Gaza Strip is illegal, and even after its 2005 redeployment, Israel remains the occupying power in Gaza. But what is the legal status of the Israeli occupation itself? The essence of an occupation under international law is that it is a temporary situation. An occupation that does not and cannot end is de facto an irreversible annexation. Inasmuch as the acquisition of territory by war is illegal under international law, an occupation that morphs into an irreversible annexation must also be illegal. In light of the International Court of Justice's jurisprudence in the Namibia case, on the one hand, and Israel's persistent refusal to negotiate an end to the occupation on the basis of international law, on the other, it is submitted that the Israeli occupation of the West Bank, including East Jerusalem, and the Gaza Strip, has become illegal under international law. As such, Israel has forfeited its rights as an occupying power. The one and only right still accruing to it is to execute a full withdrawal from the Palestinian territories that it illegally occupies. 1. The International Law of Occupation. 1.1. Does the legal status of an occupation depend on how it originated? 1.1.1. The broad consensus is that international law does not distinguish between a military occupation that results from a war of self-defense, and a military occupation that results from a war of aggression. The same rights and obligations, codified in the Hague Regulations, 1907, and the Fourth Geneva Convention, 1949, accrue to the occupying power in either case. It thus resembles the laws of war, which apply equally to both parties in a conflict regardless of which side initiated it and which acted in self-defense. 1.1.2. A dissenting view, based on more recent developments in international law, holds that military occupation is intrinsically illegal, as it results from the illegal use of force and violates the customary law of self-determination. The sole exception would be an occupation that both ensues from lawful use of force and is of limited duration. 1.1.2.1. Even if one subscribes to the novel contention that a military occupation is inherently illegal, and even if the Israeli occupation did not qualify as an exception, it still could not circumvent the fact that UN Security Council Resolution 242, which endures as the recognized basis for resolving the Israel-Palestine conflict, made Israel's withdrawal conditional on a negotiated agreement. However it originated, Israel's occupation cannot then be illegal by virtue of it being an occupation. 1.1.2.2. The preambular paragraph of a December 1975 General Assembly resolution, Implementation of the Declaration on the Granting of Independence to Colonial Countries and Peoples, 3481, recited that any military occupation, however temporary, constituted an act of aggression, and an operative paragraph accordingly condemned Israel's occupation of Arab territories in violation of the Charter of the United Nations, the principles of international law and repeated United Nations resolutions. But this isolated resolution does not appear to have had political consequence or diplomatic resonance. 1.1.3. In the early years of the occupation, it was alleged by Israel's supporters that insofar as Israel came to administer the Arab territories, while fighting a defensive war, it was a lawful entrant that has a right of occupation, pending conclusion of a peace treaty. If the Israeli occupation was legal, it was allegedly because it sprang from a war of self-defense. 1.1.3.1 This contention was anchored in the two-pronged claim that Israel, believed it, faced an imminent Egyptian attack when it struck in 1967, and that Israel's resort to force was subsequently validated by the United Nations. A careful reading of the documentary record shows, however, that an Egyptian attack was not impending. Israeli leaders did not fear such an attack, and the international community did not ex post facto embrace Israel's narrative of the chain of events climaxing in its first strike. 1.1.4 Even though the international community did not embrace Israel's narrative of how it came to occupy Arab lands, it did not call on Israel to unilaterally withdraw. After protracted debate, first in the General Assembly and then in the Security Council, the United Nations resolved, in 242, to make an Israeli withdrawal from occupied Arab territory, in accordance with the customary rule of the inadmissibility of the acquisition of territory by war, conditional upon the termination of all claims or states of belligerency by neighboring Arab countries, in accordance with the principle of international law barring threat or use of force against the territorial integrity or political independence of any state. 1.1.5 The essential picture, then, is that the legality of Israel's occupation does not hinge on how it originated. Whether the occupation resulted from a war of self-defense or a war of aggression is beside the point. Even if Israel's claim of self-defense could be shown to be false, still Israel was not legally bound to withdraw so long as neighboring Arab countries did not recognize its reciprocal rights as a state. The Israeli occupation had no time limit and could, from the legal point of view, continue indefinitely. Former Israeli Chief Justice Meir Shamgar inferred, pending an alternative political or military solution. 1.2 The legal status of a recalcitrant occupier. 1.2.1 But could the Israeli occupation, from the legal point of view, continue indefinitely, if Israel balked at withdrawal even after Arab states expressed a readiness to recognize it? Shamgar entered the critical caveat, pending an alternative political solution. What if Israel were offered such a solution, but rejected it? 1.2.2 This question first arose in the context of Israel's occupation, following the 1967 War of the Egyptian Sinai. In the course of UN-mandated mediation, the Ojaring mission, Egypt had agreed to a full peace treaty with Israel, but Israel still refused to withdraw from the Sinai. Once these negotiations broke down, and all avenues toward a diplomatic settlement were thwarted by Israeli intransigence, Egypt repeatedly warned that it would go to war in order to recover the occupied Sinai. It made good on this threat in 1973. 1.2.2.1 Just before Egypt launched its offensive, the UN Security Council convened to deliberate on the diplomatic impasse. Israel purported that per Resolution 242, it was not obliged to withdraw until and unless a mutually agreed upon resolution of the conflict was reached. The Kingdom of Jordan cogently rejoined, however, that disputing axiomatic legal principles did not constitute negotiations but, instead, was tantamount to evading a settlement. 1.2.2.2 A draft resolution tabled at this council session strongly deplored Israel's continuing occupation of the territories occupied as a result of the 1967 war. In his gloss on the resolution, the Indian drafter stated, "We totally reject any claim that either Resolution 242, 1967, or the ceasefire agreement in any way gives tolerance, much less authority, direct or indirect, tacit or implicit or explicit, for Israeli forces to continue to occupy Arab territories. The United States vetoed the resolution on the grounds that condemning the Israeli occupation bears no relationship to the provisions and principles of Resolution 242, 1967. But the consensus opinion minus the American delegate was that once Israel refused to negotiate a peaceful settlement based on international law, it effectively forfeited its right to be an occupant. In keeping with this determination, after Egypt crossed the Suez Canal in October 1973 in order to eject the Israeli occupier and recover the Sinai, not a single government accused Egypt of aggression, as Abba Eban later wrote in his memoir, not even the United States. 1.2.3 The scholarly literature on the law of occupation makes scant mention of the legal status of a recalcitrant occupier. The most comprehensive study to date, Yutaka Arai Takahashi's The Law of Occupation, Continuity and Change of International Humanitarian Law, and its interaction with international human rights law, doesn't contemplate such a scenario. Yoram Dinstein's The International Law of Belligerent Occupation disposes of the myth that an occupation becomes in time inherently illegal under international law in one curt, unenlightening paragraph. 1.2.3.1, an article by Orna Ben Naftali, Isle Gross, and Karen McKelly, Illegal Occupation, Framing the Occupied Palestinian Territory, is often cited by writers who assert that Israel's occupation is illegal. It argues, albeit in occasionally opaque language, that the infrastructure Israel has entrenched in the West Bank, settlements, bypass roads, the wall, etc., constitutes a de facto annexation, in violation of the basic principle of temporariness that defines an occupation, and that Israel has also committed gross violations of humanitarian and human rights norms in the annexation process. The cumulative effect of these illegal Israeli actions, the authors conclude, has been to render the occupation illegal. The force of this thesis is that Israel has been pursuing policies that will eventually and inexorably make the occupation irreversible, in breach of its obligations as an occupier, on the one hand, and the Palestinian right to self-determination, on the other. But inasmuch as Israeli settlements, etc., have not yet made the occupation irreversible, it appears legally more nuanced, and in keeping with precedent, to discreetly condemn the illegal Israeli practices without, however, declaring the occupation as such illegal. 1.2.3.1.1 The UN Security Council has designated Israel's settlement policy and annexation of East Jerusalem illegal, and the General Assembly has referred to Israel's de facto annexation of large areas of territory. 1.2.3.1.2, in its 2004 landmark advisory opinion, Legal Consequences of the Construction of a Wall in the Occupied Palestinian Territory, the International Court of Justice, ICJ, more tentatively stated, the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case, and notwithstanding the formal characterization of the wall by Israel, it would be tantamount to de facto annexation. In a separate opinion, however, Judge Koroma concluded without qualification that the construction of the wall has involved the annexation of parts of the occupied territory by Israel. 1.2.3.1.3 Eminent international law specialist James Crawford has observed that the Israeli settlements constitute a de facto annexation of West Bank territory that has prevented the Palestinian people from exercising their right to self-determination. 1.2.3.1.4 However, neither the Security Council nor the General Assembly, neither Judge Koroma nor Crawford, determined that Israel's annexation of Palestinian territory perforce rendered the occupation itself illegal. The prudent determination would appear to be that even if an occupier's recalcitrance has over time resulted in a de facto, or, in the case of East Jerusalem, de jure, annexation, it doesn't yet illegalize the occupation as such. 1.2.3.1.5 For the record, Israel's official position is that the Jewish settlements, and the wall running along the periphery of the major settlement blocks, are inherently temporary. Israel High Court of Justice, and do not annex territories to the State of Israel. In the course of the wall's construction, however, senior Israeli government officials, including former Justice Minister Tzipi Livni, former Prime Minister Ariel Sharon, and former Defense Minister Ehud Barak, publicly conceded that the wall marked off Israel's future border. 1.2.3.2 Israeli legal scholar Eyal Benvenisti tackles the legal challenge posed by a recalcitrant occupier from a different angle, in the international law of occupation. He begins, like Shamgar, by asserting that international law neither limits the duration of the occupation, n, or requires the occupant to restore the territories to the sovereign before a peace treaty is signed. However, Benvenisti then enters this caveat: an occupation regime that refuses to earnestly contribute to efforts to reach a peaceful solution should be considered illegal. Indeed, such a refusal should be considered outright annexation. The occupant has a duty under international law to conduct negotiations in good faith for a peaceful solution. It would seem that an occupant who proposes unreasonable conditions, or otherwise obstructs negotiations for peace for the purpose of retaining control over the occupied territory, could be considered a violator of international law. He goes on to observe that an occupant that in bad faith stalls efforts for a peaceful ending to its rule would be considered an aggressor, and its rule be tainted with illegality. 1.2.4 The determination that if an occupier negotiates in bad faith, then it has tainted the occupation with illegality was in fact already arrived at in the Namibia case. After protracted, fruitless negotiations, the UN General Assembly followed by the Security Council passed resolutions declaring South Africa's occupation of Namibia illegal, and subsequently the ICJ upheld the validity of these UN decisions. The Namibia case bears strong resemblances to the Israeli occupation of Palestinian territory. Its unfolding and denouement provide a roadmap for the international community as it confronts another recalcitrant occupier. 2.0 The Namibia case. 2.1 Historical context. 2.1.1 Although largely forgotten today, in the mid-20th century the Namibia Mandate of South Africa prompted more resolutions, promoted more committees and produced more judicial decisions, recalled leading authority John Dugard, than any other matter to come before the organs of the United Nations. It was, in Dugard's words, the international cause célèbre, or, as one of the ICJ judges hearing the case put it, the most explosive international issue of the post-war world. In later years, it was displaced on the international agenda by the larger question of South African apartheid, of which Namibia was henceforth a subsidiary issue, and by the Palestine question, which was the other gaping wound lingering from the mandate's era. 2.1.2 After seizing power in Russia, the Bolsheviks denounced World War I as imperialistic, and trumpeted their support for the principle of self-determination of oppressed nations. Largely in reaction and as a result, U.S. President Woodrow Wilson himself championed the right of self-determination and imposed on the Allied powers the principle of non-annexation of the colonies of the defeated Central Powers. 2.1.3 A mandate system was created at war's end and codified in Article 22 of the League of Nations Covenant. Each of the former colonies of the Central Powers, allegedly not yet able to stand by themselves under the strenuous conditions of the modern world, came under the tutelage of an advanced nation that was mandated to prepare it for the exercise of self-determination. The tutelary role of the mandatory power, acting on behalf of the League to promote the ex-colonies' well-being and development, was denoted a sacred trust of civilization. 2.1.4 The mandate over the former German colony of Namibia, Southwest Africa, was conferred on His Britannic Majesty to be exercised on his behalf by the Government of the Union of South Africa. Under the mandate's terms and subject to oversight by the League, and ultimately the Permanent Court of International Justice, South Africa was obliged to promote to the utmost the material and moral well-being and the social progress of the inhabitants. 2.1.5 After the League's dissolution in 1946, it was clearly contemplated that the Namibia Mandate would be converted into a UN trusteeship, en route to statehood. South Africa envisaged a different future, however, as it was intent on annexing Namibia, or the most desirable parts thereof. 2.1.6 Hence ensued a protracted political and legal tug-of-war. The United Nations, led by a contingent of African states, demanded that South Africa recognize the General Assembly's supervisory powers and Namibia's right to independence, while in the face of Pretoria's persistent stonewalling, it simultaneously kept referring the Namibia question to the ICJ in order to clarify and certify South Africa's legal obligations. 2.1.7 A sequence of contentious and divisive proceedings unfolded at The Hague. 2.1.7.1 In a 1950 advisory opinion, International Status of Southwest Africa, the ICJ concluded that even after dissolution of the League of Nations, South Africa was still duty-bound to promote the material and moral well-being and the social progress of the inhabitants, that the League's supervisory powers over South Africa's mandate had been transferred to the General Assembly, and, controversially, that although it was expected that the mandatory states would follow the normal course indicated by the Charter, namely, conclude trusteeship agreements, still South Africa was not legally obligated to convert its mandate into a UN trusteeship, but it also couldn't unilaterally modify Southwest Africa's international status. 2.1.7.1.1 In a cluster of dissents on this last point, Judge Alvarez asserted that the Union of South Africa has the legal obligation to negotiate and conclude an agreement with the United Nations to place Southwest Africa under trusteeship. Judge de Vischer, supported by Vice President Guerrero, Judge Zarisic, and Judge Badawi Pasha, opined that South Africa incurred a legal obligation to be ready to take part in negotiations and to conduct them in good faith with a view to concluding a trusteeship agreement, and Judge Krulov maintained that South Africa was under the legal obligation to negotiate with a view to concluding a trusteeship agreement. 2.1.7.2 A 1955 advisory opinion, Southwest Africa, voting procedure, hinged on a technical point regarding the substance and procedure of General Assembly oversight of South Africa's Namibia mandate. The court upheld the Assembly's prerogatives. 2.1.7.3 In a 1956 advisory opinion, admissibility of hearings of petitioners by the Committee on Southwest Africa, the court upheld the General Assembly's right to make use of supplementary procedures, such as oral testimonies by Namibian petitioners before a UN subcommittee, to facilitate its supervisory function in the face of South African intransigence. 2.1.8 The proceedings at The Hague reached a tempestuous denouement in a pair of complementary yet contradictory court decisions, in 1962 and 1966. 2.1.8.1, Ethiopia and Liberia, both formerly belonging to the League of Nations, invoked a clause of the League mandate enabling then member states to contest via court adjudication a mandatory's conduct. They requested from the ICJ not an advisory opinion but an enforceable judgment on, inter alia, their contention that South Africa had breached its obligations to promote to the utmost the material and moral well-being and social progress of the inhabitants of Namibia, and instead practiced apartheid, i.e., it has distinguished as to race, color, national or tribal origin, in establishing the rights and duties of the inhabitants. 2.1.8.2, the famous case divided into two theoretically discrete phases, jurisdiction and merits. In its 1962 judgment, the court answered affirmatively that it had jurisdiction to render a decision. But then in the 1966 judgment, when it was due to decide on the merits of the case against South Africa, the ICJ effectively reversed itself, declaring, in the most controversial judgment in its history, that it in fact lacked jurisdiction, as the applicant states could not demonstrate any legal right or interest appertaining to them in the subject matter of their brief against South Africa. 2.1.8.3, whereas both phases of the case formally turned on technical, linguistic, and historical arcana, what Judge Forster in his dissent rightly ridiculed as an arid scrutiny and relentless analysis, and whereas it was subsequently purported by judges in the case and by legal commentators alike, that it was conflicting judicial philosophies, teleologists versus positivists, that rent the court, a disinterested observer cannot but conclude that each side was able to marshal compelling evidence that the case each side mounted at The Hague was tendentious, and that the schism on the court was, at its core, and however crude and reductionist it might sound, political. The Old World colonial powers straining to reign in the non-Western upstarts, albeit with the curious anomaly that whereas the Old World was predictably represented by a tenacious and learned, if frankly obnoxious, Brit on the court, Judge Fitzmaurice, his arch-nemesis, who was also every bit his athletic and intellectual match, happened to be an American, Judge Jessup. In a rare departure from judicial etiquette, which sustains the illusion of law standing above the political fray, Judge de Castro, in a later separate opinion, baldly, but still accurately, depicted the ICJ proceedings on Namibia as in their essence, the struggle between the colonialists and progressives. 2.2, South Africa's failure to negotiate in good faith, UN deliberations. 2.2.1, appalled by the ICJ's dismissal by deflection of the case against South Africa, and the attendant squandering of years of time and resources invested in legal proceedings, the United Nations took a series of dramatic and drastic steps to right the court's wrong. A 1966 General Assembly Resolution, 2145, terminated South Africa's mandate over Namibia. A 1967 Resolution, 2325, declared that the continued presence of South African authorities in Southwest Africa is a flagrant violation of its territorial integrity, and a 1968 Resolution, 2372, condemned the action of South Africa to consolidate its illegal control over Namibia, and called upon all states to desist from those dealings with the government of South Africa, which would have the effect of perpetuating South Africa's illegal occupation. 2.2.2, emphasizing the inalienable right of the Namibian people to freedom and independence and the legitimacy of their struggle against foreign occupation, the General Assembly justified its resolve, in 2145, to terminate South Africa's illegal occupation under 3 heads. Breach of international obligations. South Africa's administration in Namibia violated the mandate, the Charter of the United Nations and the Universal Declaration of Human Rights. Imposition of apartheid. The policies of apartheid and racial discrimination practiced by the government of South Africa in Southwest Africa constituted a crime against humanity, and failure to negotiate in good faith. The efforts of the United Nations to induce the government of South Africa to fulfill its obligations in respect of Namibia have been of no avail. 2.2.3 For the purposes of the argument presented here, the focus in this text will be on the last of these rationales. 2.2.4 The failure of South Africa to negotiate in good faith had already been mooted in the ICJ deliberations on Namibia prior to the General Assembly resolutions. 2.2.4.1 In a dissenting opinion, 1950, Judge Alvarez stated, it would not be possible to admit that an agreement which is intended to fix an important international status cannot be established solely because of the opposition, the negligence, or the bad faith of one of the parties. If it is impossible to reach such an agreement, the United Nations must then take the appropriate measures. In a cognate dissenting opinion, 1950, Judge de Vischer, albeit more restrainedly, stated, the mandatory power, while remaining free to reject the particular terms of a proposed agreement, has the legal obligation to be ready to take part in negotiations and to conduct them in good faith with a view to concluding an agreement. 2.2.4.2 In a separate opinion, 1962, Judge Bustamante pointed to the overwhelming proof not only of the fact that repeated and reiterated negotiations took place, but also that all the efforts made to find a conciliatory solution resulted in failure. For 15 consecutive years, this fundamental opposition of points of view, this unyielding opposition of the mandatory in the face of the virtual unanimity of member states as to the limits and obligations flowing from the mandate, have maintained a situation of permanent deadlock. He proceeded to conclude that no negotiation is possible and that any further negotiation would be ineffective. To settle the dispute, counseling instead resort to judicial decision at The Hague in order to re-establish the harmonious functioning of the system. 2.2.4.3 In a separate opinion, 1962, Judge Jessup observed that although there certainly is no absolute litmus test which would enable a court to assert in all situations at just what moment settlement by negotiation becomes impossible, it seems clear on the face of the record that the condition is fulfilled in this case. States, he pithily concluded, are not eternally bound by the old adage, if at first you don't succeed, try again. 2.2.5 The General Assembly debates that culminated in a cascade of resolutions terminating South Africa's mandate and condemning its illegal occupation of Namibia zeroed in on South Africa's obduracy during negotiations, while also ridiculing South Africa's appeal to guard against the shutting of doors to further dialogue which is so necessary for better understanding and cooperation. 2.2.5.1 Whereas the member states contended that the objective of negotiations was to secure Namibia's eventual independence, South Africa insisted on negotiations without set preconditions or a predetermined outcome, technically leaving open all possibilities, but in reality excluding real independence. 2.2.5.2 The Ethiopian delegate gestured to the fact that all avenues of peaceful negotiations have already been exhausted, while the Norwegian delegate noted, after 20 years of futile discussions about the South African administration of Southwest Africa, the consensus has arisen that South Africa has lost its right to administer the territory and that its mandate is terminated. 2.2.5.3 In the face of the unbelievable intransigence of the government of South Africa, the Uruguayan delegate recollected, we find a whole slew of General Assembly resolutions covering a period of 20 years and urging Pretoria to fulfill its duties and assume its responsibilities before the international community. W.E.C. An accumulation of acts of insubordination, violation, of disregard of authority, abuse of rights, disobedience, mockery and defiance committed by South Africa against the United Nations. We have waited over 20 years. Let us hope that moderation will not become the vice of weakness. We are supported by law, by rights, by morality, by the will of the whole world. The time has come to put an end to this struggle between law and arrogance. The organ of the international community must end the mandate on the grounds of repeated and malicious non-fulfillment of the obligations and duties inherent in it. 2.2.5.4 After recalling that, or over 15 years we have waited for the South African government to comply with its clear obligations, and that, repeated attempts by the General Assembly to persuade the South African government to adopt a policy of cooperation have been unsuccessful, the British delegate, Lord Caradon, who would later craft UN Security Council Resolution 242, declared that South Africa has, in effect, forfeited its title to administer the mandate. 2.2.5.5 The Israeli delegate, joining the majority, observed that the Assembly had turned to the ICJ in 1966 for a binding decision only after a deadlock had been reached in negotiations with South Africa to secure implementation of the 1950 ICJ advisory opinion on Namibia, that after the ICJ shied away from deciding the case in 1966, the decision now falls clearly on the shoulders of the General Assembly, and that South Africa was in breach of its major obligations because it did not prepare Namibia for independence. In a passage worth quoting at length, the Israeli delegate concluded, nearly 50 years after the mandate was conferred on and accepted by the mandatory power, Southwest Africa seems no nearer independence than it ever was. It is an ironic reflection that nearly all the other African peoples live under their own national sovereignty, while, in the case of Southwest Africa, and only in that case, the sacred trust of civilization remains not only unfulfilled, but also not even within sight of fulfillment. It is a fact that all efforts to reach a mutually acceptable and reasonable settlement have been exhausted. Since the mandatory power is failing to fulfill its essential obligations under the mandate, it follows that the United Nations is free to take appropriate action. We believe that the General Assembly is now entitled to terminate the mandate. The General Assembly should take decisions on the future of the mandated territory on the assumption that the mandate may be lawfully and properly terminated by the General Assembly. If the time frame is enlarged to nearly 100 years after the mandate, and if the statement that Southwest Africa was the only mandate where independence had not been within sight of fulfillment, is amended by interpolating that the statehood of the indigenous population under the Palestine Mandate also was, and continues to be, placed on hold, then the pertinence and unique resonance of the Israeli ambassador's observations, both as to diagnosis, all efforts to reach a mutually acceptable and reasonable settlement have been exhausted, and as to proposed remedy, the General Assembly is now entitled to terminate the mandate, can hardly escape notice. 2.2.5.5.1 A few months later, the Israeli delegate told the Assembly, "The problem of Southwest Africa, which has developed into an intolerable situation, has been before the United Nations since its very first meetings over 21 years ago. Every conceivable approach to reaching a solution, which would conform to the principles of the Charter and assure the people of that land of their fundamental rights, has been thwarted. The United Nations has shown patience and even leniency in the face of the stubborn stand persisted in by the government of South Africa in utter disregard of the clearly expressed position of the United Nations." In an earlier address, Israeli Foreign Minister Abba Eban exhorted the Assembly to insist that a mandatory power forfeits its mandate when it flagrantly and constantly violates the central aims for which the trust was conferred. 2.2.5.6 The U.S. delegate, also standing with the Assembly majority in the deliberations, declared that by virtue of the breach of its obligations, South Africa forfeits all right to continue to administer in Namibia. Despite the walls of censorship and propaganda, with which their own government has surrounded them, he prognosticated, the people of South Africa must soon realize that the system they are trying to entrench in Namibia will not work, that it will neither satisfy the wants and needs of the non-white population nor, by some conjuring trick, conveniently make them disappear. 2.2.5.6.1 The United States condemned South Africa as well for its imposition in Southwest Africa of its universally condemned policy of apartheid, and for its clear defiance of the General Assembly's wise injunction that South Africa refrain and desist from any action, constitutional, administrative, political or otherwise, which will in any manner whatsoever alter or tend to alter the present international status of Southwest Africa. 2.2.5.6.2 What's more, the United States opined that if some Namibians living under occupation resorted to force, it was at root a reaction to South Africa's repressive tactics that bred desperation, and in that desperation, some have found no alternative to violence as an expression of the determination to be free. The United States does not condone violence. The United States does condemn the brutality of a government whose official policies have bred violence by closing avenues of peaceful dissent in Southwest Africa, thereby generating the very behavior it seeks to punish. 2.2.5.6.3 The actions of the United States did not, however, rise to its lofty rhetoric. The United States of America is economically and militarily the strongest among us, a Caribbean delegate observed. If it wished it could, I have no doubt, reduce the government of South Africa single-handedly, and indeed, it could do this even if the rest of us were to raise our voices against it. But even as, we have heard the representative of the United States regret, abhor, and condemn the behavior of South Africa in this very chamber, he went on to rue the existence of a domestic lobby, that is, sufficiently influential, may cause even the most determined government to pause. Plus ca change, plus say la même chose. 2.2.6 Although lagging behind, the Security Council eventually echoed the resolve of the General Assembly. 2.2.6.1 The Council was first seized of the Namibia question in early 1968 when a resolution, 245, took note of the Assembly's termination of the mandate and expressed grave concern over South Africa's illegal repression in Namibia, while another resolution, 246, later that year censured the government of South Africa for its flagrant defiance of the Security Council. 2.2.6.2, a 1969 resolution, 264, took note of the grave consequences of South Africa's continued occupation of Namibia, affirmed that the continued presence of South Africa in Namibia is illegal, and called upon the government of South Africa to immediately withdraw its administration from the territory. A follow-up resolution, 269, later in the year declared that the continued occupation of the territory of Namibia by the South African authorities constitutes an aggressive encroachment on the authority of the United Nations, recognized the legitimacy of the struggle of the people of Namibia against the illegal presence of the South African authorities in the territory, and called upon South Africa to withdraw its administration from the territory immediately. 2.2.6.3 Faced with Pretoria's refusal to either negotiate in good faith or withdraw, the Security Council, in a 1970 resolution, 276, declared that the United Nations decided that the mandate for Southwest Africa was terminated, that the continued presence of the South African authorities in Namibia is illegal, and that consequently, all acts taken by the government of South Africa on behalf of or concerning Namibia after the termination of the mandate are illegal and invalid. It also called for the creation of a subcommittee to study ways and means of implementing the relevant UN resolutions, in the light of the flagrant refusal of South Africa to withdraw from Namibia. A few months later, the subcommittee recommended that the United Nations seek another ICJ advisory opinion. 2.3 South Africa's failure to negotiate in good faith, back to The Hague. 2.3.1 Pursuant to the subcommittee's recommendation, the Security Council adopted, in 1970, a pair of complementary resolutions. The first of these, 283, reaffirmed its recognition of the decision of the General Assembly to terminate the mandate of South Africa, noted, with great concern, the continued flagrant refusal of the government of South Africa to comply with the decisions of the Security Council demanding immediate withdrawal, and called upon all states maintaining diplomatic or consular relations with South Africa to issue a formal declaration to the effect that they consider South Africa's presence in Namibia illegal. The succeeding resolution, 284, referred the Namibia question back to the ICJ. 2.3.1.1 Defending this course of action against skeptics still smarting from the court's 1966 snub, see supra. 2.1.8.2, the Finnish delegate on the Security Council stressed that an advisory opinion of the International Court of Justice could underline the fact that South Africa has forfeited its mandate over Southwest Africa because South Africa has acted contrary to international law. It is important to expose the false front of legality which South African authorities attempt to present to the world. This would help mobilize public opinion, especially in those countries which have the power to influence events in Southern Africa in a decisive way. 2.3.1.2 During the Security Council debate, the American delegate excoriated the callous behavior of the illegitimate occupying authority. Although South Africa has cloaked itself in a mantle of seeming legality, he declared in another council meeting, the legal justifications for its actions are spurious. Not only do these actions run contrary to actions by the political organs of the United Nations, but, in addition, the International Court of Justice has also made clear the international responsibility of South Africa with respect to the territory. Its authority was conditioned by the obligation to look to the welfare of the inhabitants. Surely, by applying its apartheid laws in the territory, it did not honor but rather breached that obligation. In still a third intervention, the United States denounced South Africa for not only attempting to annex Namibia, but also extending its heinous policy of apartheid to that territory. And in a fourth council meeting, it deplored South Africa's policy of virtual annexation. It has compounded this evil by applying to the international territory the odious practice of apartheid, with all the miserable human consequences that that practice entails. Nonetheless, the United States opposed international sanctions allegedly because they would, likely, prove ineffective and would, far from improving the lot of the Namibians, run the risk of making their situation even worse than it is today. 2.3.2 The Security Council requested of the ICJ an advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia, Southwest Africa, notwithstanding Security Council Resolution 276, 1970. 2.3.3 The Court's opinion, delivered in 1971, divided, for the purposes here, into two sections, the rationale behind the General Assembly resolution terminating the mandate, and the competence, power, of the Assembly to terminate the mandate. 2.3.3.1 The advisory opinion first sketched in the background to the General Assembly's decision to terminate and declare illegal South Africa's occupation. It noted that, throughout a period of 20 years, the General Assembly called upon the South African government to perform its obligations arising out of the mandate, that the Assembly passed a succession of resolutions beginning in 1946 reminding South Africa of its obligations, and urging it to comply with them, that the United Nations undoubtedly conducted the negotiations in good faith, yet even the compromise proposals mooted by it were rejected by South Africa, and that further fruitless negotiations were held. The court then concluded, in practice, the actual length of negotiations is no test of whether the possibilities of agreement have been exhausted. It may be sufficient to show that an early deadlock was reached and that one side adamantly refused compromise. In the case of Namibia, Southwest Africa, this stage had patently been reached long before the United Nations finally abandoned its efforts to reach an agreement. Even so, for so long as South Africa was the mandatory power, the way was still open for it to seek an arrangement. But that chapter came to an end with the termination of the mandate. 2.3.3.1.1 In his separate opinion, Judge Dillard, of the U.S., pointedly observed that negotiations become a mockery if the core assumptions of the contending parties cannot be reconciled. It is apparent that no negotiating process can be successful if the parties are at odds as to the fundamental basis on which the process rests. Quite obviously, negotiations based on conflicting premises qualify, at best, as an empty time-consuming pageant and, at worst, as a mere dialogue of the deaf. 2.3.3.1.1.1 In the passage preceding these remarks, Dillard rebuked South Africa for its disingenuous negotiating posture. The dilemma is focused on the negotiating process consequent upon the dissolution of the League of Nations. Although South Africa was under no duty to submit to the trusteeship system or to negotiate a specific trusteeship agreement, yet, As a member of the United Nations, she was surely under a duty to negotiate in good faith with the United Nations concerning a viable alternative either within the trusteeship or outside it. In the corresponding footnote, Dillard contested a fellow judge's opinion that even if a member state of the United Nations is bound to consider in good faith an assembly resolution, it does not entail a true legal obligation. I cannot agree with this conclusion. The use of discretion and freedom to bargain which the system may confer does not imply the right to exercise an attitude of uninhibited freedom of action which would be tantamount to operating outside the system. 2.3.3.1.2 In his dissenting opinion, Judge Groh, although gainsaying that either the General Assembly or the Security Council had the power of revocation of the mandate, nonetheless concurred that South Africa was under a legal obligation to negotiate in good faith. The relevant passage merits lengthy quotation as it lends unexpected support from a dissenting judge to the majority opinion. On the decisive point of good faith, the conflict of standpoints can be roughly summarized as follows. The aim of the United Nations was to arrive at the negotiation of a trusteeship agreement, whereas South Africa did not want to convert the mandate into a trusteeship. It is necessary to determine which party has been misusing its legal position in this controversy on the extent of the obligation to negotiate. If negotiations had begun in good faith and if, at a given juncture, it had been found impossible to reach agreement on certain precise, objectively debatable points, then it might be argued that the opinion of 1950, finding as it had that there was no obligation to place the territory under trusteeship, prevented taking the matter further, inasmuch as the mandatory's refusal to accept a draft trusteeship agreement could in that case reasonably be deemed justified. No party can impose its terms on the other party, quoting the 1950 ICJ advisory opinion, see supra. 2.1.7.1. But the facts are otherwise. Negotiations for the conclusion of a trusteeship agreement never began, and for that South Africa was responsible. The rule of law infringed herein is the obligation to negotiate in good faith. To assert that the United Nations ought to have accepted the negotiation of anything other than a trusteeship agreement on basis proposed by South Africa, that, coming from the government of South Africa, is to interpret the 1950 advisory opinion contrary to its meaning. In seeking to impose on the United Nations its own conception of the object of the negotiations for the modification and transformation of the mandate, South Africa has failed to comply with the obligation established by the 1950 opinion to observe a certain line of conduct. The United Nations, on the other hand, was by no means misusing its legal position when it refused to negotiate with any other end in view than the conclusion of a trusteeship agreement, for such indeed was the goal acknowledged by the 1950 opinion. It would have been legitimate for the United Nations to have taken note of the deadlock and demanded South Africa's compliance with its obligation to negotiate. This view is reinforced by South Africa's consistent interpretation of its own powers, whether it be its pretension to the incorporation of the territory, something essentially incompatible with the mandate regime, or its contentions with regard to its legal titles apart from the mandate. The legal position of mandatory formally recognized by the court in 1950 gave South Africa the right to negotiate the conditions for the transformation of the mandate into a trusteeship. Since 1950 that position has been used to obstruct the very principle of such transformation. An analysis on these lines, if carried out by the court and based on a judicial finding that there had been a breach of the obligation to transform the mandate by negotiation, as the 1950 opinion prescribed, would have had legal consequences in respect of the continued presence of South Africa in the mandated territory. I consider that, in that context, the legal consequences concerned would have been founded upon solid legal reasons. However, insofar as Groh denied that the United Nations could revoke the mandate, it is unclear what legal consequences in respect of the continued presence of South Africa in the mandated territory he had in mind. After delineating the deadlock caused by South Africa's refusal to conduct good faith negotiations, the court next considered whether the General Assembly had the competence to terminate the mandate, or whether it had acted ultra vires, beyond its legal powers. The court decided that it was within the Assembly's province. As a general rule, Assembly resolutions are only recommendations. The court found, however, that the League of Nations relationship with the South African Mandatory included a treaty, contract, component, that it is inherent in a treaty agreement that if one party materially breaches its obligations, the other party has a right to terminate it, and that, consequently, once the League's powers had been transferred to the Assembly, and South Africa had deliberately and persistently breached its obligations under the mandate, the Assembly's competence extended beyond making a recommendation to making a binding legal decision. In sum, the court concluded that it would not be correct to assume that because the General Assembly is in principle vested with recommendatory powers, it is debarred from adopting, in specific cases within the framework of its competence, resolutions which make determinations or have operative design. In his separate opinion, Judge Nervo enlarged on the Assembly's competence beyond breach of a treaty to make legally binding decisions. The fact that, broadly speaking, the General Assembly's activities are mainly of a recommendatory character does not mean that the General Assembly cannot act in a situation in which it is a party to a contractual relationship in its capacity as such a party, nor does it mean that, in regard to a territory which is an international responsibility, and in regard to which no state sovereignty intervenes between the General Assembly and the territory, the General Assembly should not be able to act. As it did, the General Assembly is the competent organ of the United Nations to act in the name of the latter in a wide range of matters, and in these instances it is the United Nations itself which is acting. This is especially so concerning trusteeship matters, non-self-governing territories. South Africa has, in reality and to all effects, annexed as its own the territory of Namibia. This behavior is sufficient grounds for the revocation of the mandate. So is the racial discrimination practiced as an official policy in Namibia with the enforcement there of the system of apartheid. Racial discrimination as a matter of official government policy is a violation of a norm or rule or standard of the international community. In an editorial the morning after the ICJ handed down legal consequences for states, the New York Times hailed the historic 13-2 verdict that has cleared away the legal and political fog that for years obscured the status of Namibia. Later that same year, the Security Council accepted the key findings of the court. The U.S. delegate at the council meeting registered Washington's backing of the conclusions, which declare that South Africa is under obligation to withdraw its administration from Namibia immediately and thus put an end to its occupation, and it also observed that the U.S. position was consistent with our support of practical and peaceful means to achieve self-determination and end racial discrimination. It remains to consider if the Namibia precedent can dispel the legal and political fog that has for years shrouded Israel's occupation of Palestinian territory and, in particular, shed light on the means to achieve self-determination and end racial discrimination there. 3.0 Namibia and Palestine juxtaposed. 3.1 In 2002, UN Secretary-General Kofi Annan conveyed to the Security Council that Israel must end its illegal occupation of the West Bank and Gaza. His characterization triggered a swift response from Israel's defenders, who asserted that the occupation was legal until Israel was able to negotiate a successful peace treaty. 3.1.1 In a palpable retreat, the spokesman for the Secretary-General issued a clarification stating that Annan had indicted not the Israeli occupation as such, but rather Israel's breach of its various obligations as an occupying power. 3.2 Bearing in mind the sage counsel of Judge Dillard that analogies are always to be indulged with caution, it is nonetheless submitted that in light of the Namibia precedent, Israel's occupation of Palestinian territory is now illegal, as it has persistently refused to negotiate in good faith on the basis of international law an end to the occupation. 3.3 Overlapping historical political context. 3.3.1 A common matrix molded the Namibia and Palestine questions. Both originated in the post-war mandate system, and together they constituted the salient vestiges of that era as the only mandated territories that survived dissolution of the League of Nations without being converted into UN trusteeships. 3.3.2 The UN General Assembly asserted its authority over both lingering mandates. It passed the Partition Resolution 181 in 1947, paving the way to Israel's creation, and it set out after the 1967 war to complete the unfinished business of creating a reciprocal Palestinian state. In the case of Namibia, the General Assembly early on rejected South Africa's bid to annex it, then claimed title to supervise South Africa's administration of it, then terminated South Africa's mandate and declared its occupation illegal, and finally shepherded Namibia to independence. 3.4 Overlapping legal context. 3.4.1 The Namibia and Palestine questions are juridically homologous. 3.4.1.1 If Palestine is perceived through the optic of the mandate system, then its rights carry over as a lingering mandate. In its 2004 Wall opinion, the ICJ recalled the genesis of the Palestine question in the mandate system, and the permanent responsibility, quoting a General Assembly resolution, that consequently falls on the international community. 3.4.1.2 If the Palestine question is perceived as it re-emerged after 1967, then Palestine's rights derive from its status as a territory under occupation. The ICJ's 2004 opinion, which deliberated on the legal consequences of building a wall in occupied Palestinian territory, is shot through with references to the Namibia precedent. 3.4.2 Whether the mandate system or the status of a territory under occupation served as the point of reference, the selfsame principles of a sacred trust and non-annexation governed the Namibia and Palestine situations. 3.4.2.1 The ICJ underscored on multiple occasions that the twin principles of a sacred trust, that is, the paramount importance of the well-being and development of the mandate population, and non-annexation, that is, the mandatory does not acquire any rights of sovereignty over a mandate, constituted the essence of the mandates system. 3.4.2.1.1 Judges Koroma, Alkasane, and Elarabi, in their respective opinions in the Wall case, located the obligations of a sacred trust and non-annexation in Palestine's former status as a mandate. 3.4.2.2 The principles of a sacred trust and non-annexation also figure as legal hallmarks of a territory under occupation. 3.4.2.2.1 Under international law, a classic text notes, enemy territories in the occupation of armed forces of another country constitute a sacred trust, which must be administered in the interests of the inhabitants. In the Namibia case, The court recalled that in the UN Charter, the concept of the sacred trust was confirmed and expanded to all territories whose peoples have not yet attained a full measure of self-government, Article 73, and that a further important stage in this development was the 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples, General Assembly Resolution 1514, which embraces all peoples and territories which have not yet attained independence. These precedents, although invoked in the Namibia jurisprudence, apply with comparable force to the occupied Palestinian territory, as it is subject to alien subjugation, in the language of 1514, and therefore qualifies as a quasi-colonial situation. 3.4.2.2.2 It has also been observed by commentators that the foundation upon which the entire law of occupation is based is the principle of inalienability of sovereignty through the actual or threatened use of force. Effective control by foreign military force can never bring about by itself a valid transfer of sovereignty. Judge Koroma, in his separate opinion in the Wall case, pinpointed the essence of occupation as, inter alia, its being only of a temporary nature. 3.4.3 Beyond the principles of a sacred trust and non-annexation, the non-derogable right to self-determination also inhered in the legal standing of Namibia and, later, the occupied Palestinian territory. 3.4.3.1 This right derives from the former status of each as a mandate, as well as from the rules governing decolonization after World War II, which ratified the prerogative of colonial peoples and peoples subject to foreign occupation to be independent. 3.4.3.1.1 A prominent commentator observed already decades ago that the Security Council has begun to deal with the Israeli-occupied territories as if they were colonies, while a prominent contemporary commentator places both Namibia and Palestine under the same rubric of illegal military occupation. 3.5 If South Africa's occupation of Namibia was illegal, then is Israel's occupation of Palestinian territory also illegal? 3.5.1 Whereas, per Dillard, analogies must be approached with caution, from the standpoints of history, law, and politics, it would be hard to conceive a closer fit than Namibia and Palestine. Both situations emerged historically from the mandates system. Both situations are governed by the foundational legal principles of a sacred trust and non-annexation, and both situations fall within the integral political and legal paradigms of decolonization and self-determination. 3.5.2 But does the Israeli occupation of Palestine reach the Namibian threshold of illegality? 3.5.3 The General Assembly terminated South Africa's mandate over Namibia and declared its occupation illegal on 3 counts: breach of international obligations, imposition of apartheid, and failure to negotiate in good faith. An equally compelling charge sheet can be drawn up against Israel's occupation of Palestinian territory. 3.5.3.1 Breach of international obligations. 3.5.3.1.1 The political organs of the United Nations, leading human rights organizations, and respected legal commentators have repeatedly deplored Israel's violations of international law in the occupied Palestinian territory, including excessive and disproportionate use of force, deliberate targeting of civilians and civilian infrastructure, torture, settlement construction, and collective punishment. Many of these breaches amount to war crimes and crimes against humanity. 3.5.3.1.2 These condemnations culminated in the Wall opinion, wherein the ICJ found that Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law. The Rome Statute of the International Criminal Court defines he transfer, directly or indirectly, by the occupying power of parts of its own civilian population into the territory it occupies, as a war crime. The ICJ also observed in its opinion that the route chosen for the wall severely impedes the exercise by the Palestinian people of its right to self-determination, and is therefore a breach of Israel's obligation to respect that right. The right to self-determination is widely regarded as a peremptory norm of international law, from which no derogation is permissible. 3.5.3.2 Imposition of apartheid. 3.5.3.2.1 A growing consensus has emerged, embracing authoritative legal, political, and moral personalities, among them many Israelis, that Israel has established an apartheid regime in the occupied Palestinian territory. The lengthy roster of those making the apartheid analogy in the context of Israel's occupation includes former U.S. President and Nobel Peace Prize laureate Jimmy Carter, South African Archbishop and Nobel Peace Prize laureate Desmond Tutu, and distinguished South African jurist John Dugard, former Israeli Deputy Prime Minister Dan Meridor, Likud, former Israeli Attorney General Michael Ben-Yair, former Israeli Ministers of Education Shulamit Aloni and Yossi Sarid, former Deputy Mayor of Jerusalem Meron Benvenisti, former Israeli Ambassador to South Africa Alon Leal, veteran Israeli journalist Danny Rubenstein, the Israeli Information Center for Human Rights in the Occupied Territories, B'Tselem, the Association for Civil Rights in Israel, and the Haaretz editorial board. A monograph by South African international law experts found that Israel has introduced a system of apartheid in the OPT, occupied Palestinian territory, in violation of a peremptory norm of international law, while an article published in the prestigious European Journal of International Law concluded that a system of apartheid has developed in the occupied Palestinian territory that is not only reminiscent of, but also in some cases worse than, apartheid as it existed in South Africa. 3.5.3.2.2 The reference point of the apartheid analogy is most often the dual system of law that Israel has established within the occupied Palestinian territory, that privileges Jewish settlers. But even in the absence of Jewish settlements, the occupation itself would by now constitute an apartheid regime vis-a-vis Israel proper. Some 3 decades ago, noted international law expert Adam Roberts speculated, Israel may see some advantage in the continuation of the status of the occupied territory, because this arrangement provides a legal basis for treating the Arab inhabitants of the territories entirely separately from the citizens of Israel. If a prolonged occupation, in which Israel refused to negotiate a peace treaty, came to pass, he continued, it would pave the way for a kind of apartheid. 3.5.3.2.3 After his notorious recantation and fall from grace, jurist Richard Goldstone reinvented himself as Israel's agitprop impresario. In this capacity, he deplored the apartheid analogy on the grounds that there is no intent by Israel to maintain this regime. But if Israel has persistently refused to terminate the occupation in accordance with international law, and if it has sustained the occupation for a half-century, which also comprises the largest part of its total existence as a state, and if it has entrenched an infrastructure designed to make the occupation irreversible, then Israel has, on the contrary, made manifest that it is intent on maintaining the occupation, while sufficient time has elapsed such that Roberts's premonition of an apartheid in the making has become a full-blown reality. 3.5.3.3 Failure to negotiate in good faith. 3.5.3.3.1. An overwhelming consensus exists on anchoring a solution to the Israel-Palestine conflict in international law, on the applicable general legal principles and rules of law, such as the right of both peoples to self-determination, on how to apply these general principles and rules so as to concretely adjudicate the permanent status issues of borders, East Jerusalem, settlements, and, albeit with less precision, refugees. 3.5.3.3.2. In the course of the Middle East peace process, Palestinian negotiators have consistently embraced international law as the framework for resolving the conflict, while submitting concrete proposals that protect Palestinian rights under the law but also make allowance for political expediency, such as a land swap that would enable the bulk of Israeli settlers to remain in place. Contrariwise, Israel has rejected not only the consensus interpretation of international law for resolving the conflict, but also international law itself as a baseline for negotiations. I was the Minister of Justice. I am a lawyer, Foreign Minister Tzipi Livni told her Palestinian interlocutors during a critical round of the peace process in 2007, but I am against law, international law in particular. 3.5.3.3.3. In the Namibia case, the United Nations declared the occupation illegal on, inter alia, two intertwined grounds. 1. South Africa refused to negotiate Namibia's eventual independence in good faith, that is, on the basis of international law as delineated by UN resolutions and the International Court of Justice, and 2. The premises of South Africa's negotiating posture radically diverged from consensus opinion on how to resolve the conflict. That is, Pretoria was determined to annex the whole of Namibia or the prime real estate therein occupied by white settlers. Negotiations had thus become, in Judge Dillard's words, at best, an empty time-consuming pageant and, at worst, a mere dialogue of the deaf. One would be hard-pressed to find a closer parallel to and precursor of Israel's recalcitrance in the peace process, or to improve upon Dillard's phraseology to describe the resulting diplomatic impasse. 3.5.3.3.4. In other cases adjudicated by it, the ICJ also emphasized the critical role of good faith negotiations. 3.5.3.3.4.1. In North Sea Continental Shelf, the court spoke in its judgment of an obligation to enter into negotiations with a view to arriving at an agreement, and not merely to go through a formal process of negotiation. The parties are under an obligation to act in such a way that, in the particular case, and taking all the circumstances into account, equitable principles are applied. 3.5.3.3.4.2. In the Temple of Priya Vihir case, the court pointed up in its judgment the duty to negotiate with a view to reaching agreement, and to do so in good faith, with a genuine intention to achieve a positive result. 3.5.3.3.4.3. In its advisory opinion, Legality of the Threat or Use of Nuclear Weapons, the court underscored that good faith comprised not only the conduct process of negotiations but also an obligation to achieve a precise result. 3.5.3.3.5. It follows from this sampling of the court's jurisprudence that Israel's intermittent participation in the peace process does not in and of itself demonstrate it is carrying out good faith negotiations. To pass legal muster, it must also not thwart discernible progress toward achieving its legally mandated obligation to withdraw. The premises, however, of Israel's negotiating posture, which reject not only the consensus application of international law but even international law itself, have blocked and preempt any future prospect of real movement toward an end to the occupation. 3.5.3.3.6. The the principle of a good faith, is objective in nature, as it is registered in palpable acts or failures to act. The principle of good faith is essentially objective in application. Good faith looks to the effects of state actions, rather than to the subjective intent or motivation, if any, of the state itself. Its violation may be demonstrated by acts and failures to act which, taken together, render the fulfillment of specific treaty obligations remote or impossible, or which defeat the object and purpose of the treaty. Moreover, the principle of good faith cannot but apply also to customary norms having equal status with treaty norms. Thus, states are under an obligation to refrain both from acts defeating the object and purpose of a rule and from any other acts preventing its implementation. 3.5.3.3.6.1 Israel's ongoing settlement enterprise constitutes a case study of bad faith in negotiations, as these ever-multiplying objective facts on the ground are defeating the object and purpose of negotiations, which under treaties, norms, and principles of international law requires Israel's withdrawal from the occupied Palestinian territory. The Israeli Prime Minister, Benjamin Netanyahu, publicly supports a two-state solution, but his current coalition is the most right-wing in Israeli history, with an agenda driven by its most extreme elements. U.S. Secretary of State John Kerry observed in his last major address on the Israel-Palestine conflict. The result is that policies of this government, which the Prime Minister himself just described as more committed to settlements than any in Israel's history, are leading in the opposite direction, towards one state. 3.6 Is the UN General Assembly competent to declare the Israeli occupation illegal? 3.6.1 Israel has violated its international obligations in the occupied Palestinian territory, imposed an apartheid regime there, and failed to negotiate in good faith an end to the occupation. It has consequently breached its primordial responsibilities, as an occupying power vis-a-vis Palestine, of sacred trust and non-annexation, and denied the Palestinian people its non-derogable right to self-determination. 3.6.2 If viewed through the lens of the Namibia precedent, the Israeli occupation has become illegal. But does the UN General Assembly have the competence to make such a determination in the case of the Israeli occupation? 3.6.3 The General Assembly has the authority to debate and pass resolutions on the Israeli occupation of Palestinian territory, as well as on the status and contours of the Palestinian right to self-determination. This competence derives from a trio of both general and particular sources. Article 10 of the Union Charter stipulates that the Assembly may discuss any questions or any matters falling within the purview of the United Nations and may make recommendations to the members of the United Nations or to the Security Council or to both on any such questions or matters. The Assembly is the inheritor of the supervisory powers exercised by the League of Nations over the mandate system, of which the Palestine question constitutes unfinished business. In its Wall opinion, the ICJ grounded the Palestinian people's right of self-determination in the League Covenant, the ultimate objective of the sacred trust, referred to in Article 22, Paragraph 1, of the Covenant of the League of Nations, was the self-determination of the peoples concerned. It is therefore within the province of the Assembly to supervise Palestine's quest for independence. The Assembly presided over, fleshed out the principles and rules of, and played the clinching administrative role in the decolonization/self-determination process that unfolded after World War II, which included ending the subjection of peoples to alien subjugation. In its Wall opinion, the court recalled in particular the UN's responsibility vis-a-vis the Palestine question, which has been manifested by the adoption of many Security Council and General Assembly resolutions, and by the creation of several subsidiary bodies specifically established to assist in the realization of the inalienable rights of the Palestinian people. 3.6.4 It remains to inquire whether a General Assembly resolution, which is ordinarily a recommendation, the Assembly is not a legislature, would in these circumstances also be legally binding on all member states. 3.6.4.1 In the Namibia case, it was principally argued that the supervisory powers of the League of Nations over South Africa's mandate had a treaty aspect, that a right of revocation inheres in a treaty, and that consequently the Assembly, which inherited the League's supervisory role, could make a binding legal decision to terminate the mandate after South Africa's breach of its terms. 3.6.4.2 This tortuous reasoning already at the time tested the limits of plausibility, while writers seeking in retrospect to defend the Assembly's competence in the Namibia case have developed other lines of argumentation. 3.6.4.3 In the Palestine instance, such a rationale would constitute an even less persuasive legal contrivance, not least because Israel never entered into a treaty obligation with the General Assembly comparable to South Africa's going back to the League. 3.6.5 The legally binding nature of a General Assembly resolution terminating and declaring illegal Israel's occupation can, however, be firmly established on different foundations. 3.6.6 Judge Nervo, in a separate opinion in the Namibia case, contended that the Assembly's legally binding competence obtained not only in a situation in which it is a party to a contractual relationship in its capacity as such a party, but also and more generally in regard to a territory which is an international responsibility, and in regard to which no state sovereignty intervenes between the General Assembly and the territory. He went on to observe that South Africa's annexation, in reality and to all effects, of Namibia and its policy thereof, racial discrimination, enforced by the system of apartheid, constituted sufficient grounds for the revocation of the mandate. 3.6.7 The legally binding competence of the Assembly to terminate Israel's occupation is also implied, and inherent in the supervisory function performed by it in the decolonization/self-determination process, of which Palestine, as a territory under alien subjugation, forms a constituent part. If the Assembly lacked such legal competence, it could not effectively fulfill its assigned role of safeguarding the rights of peoples entitled to but not yet exercising self-determination. Isn't a supervisory function bereft of sanctioning powers a contradiction in terms? 3.6.7.1 The cumulative effect of the serial ICJ opinions in the Namibia case supports these contentions. In International Status of Southwest Africa, the court found that safeguarding the rights of peoples under mandates had required a supervisory organ, and that the General Assembly was henceforth the appropriate organ to fulfill this necessity for supervision. In admissibility of hearings of petitioners, the court stated that the paramount purpose of the General Assembly's supervisory function was to safeguard the sacred trust of civilization. In Southwest Africa cases, first phase, preliminary objections, the court found that international supervision constituted the very essence of the mandate. In legal consequences for states, the court found that the Assembly's competence to terminate the mandate inhered in its supervisory powers. Otherwise, the Assembly would be impotent in the face of egregious violations by South Africa of its responsibilities to deny to a political organ of the United Nations, which is a successor of the League in this respect, i.e., its supervisory role, the right to act, on the argument that it lacks competence to render what is described as a judicial decision, would not only be inconsistent but would amount to a complete denial of the remedies available against fundamental breaches of an international undertaking. 3.6.7.2 The upshot of these court opinions is as follows. 1. Protection of the rights of peoples not yet self-governing required a supervisory organ. 2. The General Assembly was the competent organ to safeguard this sacred trust. 3. Absent the power of revocation, the Assembly could not effectively perform its critical supervisory role. Therefore, 4. The Assembly's power of revocation necessarily inheres in the supervisory function delegated to it. 3.6.7.3 Judge de Castro, in a separate opinion in the Namibia case, forcefully laid out the internal logic linking this chain of arguments. He elucidated that insofar as legal concepts, such as a trust, essentially contemplate the protection of persons, in this case, peoples, who cannot govern themselves, the necessary consequence is the exercise of supervision over the person entrusted with guardianship, supervision of the guardian, and in case of serious breaches of his duties, fides fracta, the loss or forfeiture of guardianship. There was no need to mention revocation in the mandate. The essential nature of this concept of trust implies, clearly and evidently, the possibility of putting an end to the mandate. A mandate which could not be revoked in such a case would not be a mandate, but a cession of territory or a disguised annexation. It is difficult to believe that, on the one hand, the working of the mandates system was organized to include a permanent commission to control the mandatory's administration, and that, on the other hand, the mandatory was left free to do what he thought fit, even if it were to run counter to the very nature of the mandate, that one should put him in possession of the territory without any obligation on his part. Any interpretation which denied the possibility of putting an end to the mandate in the case of flagrant violation by a mandatory of its obligations would reduce Article 22 to a flatus vocis, empty words, or rather to a damnable mockery, by giving some color of legality to the annexation of mandated territories. 3.6.7.3.1 Judge Nervo, in a separate opinion in the Namibia case, also derived the Assembly's competence from the functions delegated to it. The General Assembly has had, under the relevant international instruments, several distinct roles in regard to Namibia, and the action which it took in this instance, i.e., termination of the mandate, finds its basis in all these roles taken either individually or together. The General Assembly acted, in its capacity as the supervisory authority for the mandate for Southwest Africa, as the sole organ of the international community responsible for ensuring the fulfillment of the obligations and sacred trust assumed in respect of the people and territory of Namibia, and as the organ primarily concerned with non-self-governing and trust territories. 3.6.8 The General Assembly's competence to terminate and declare illegal the Israeli occupation springs from, on the one hand, its locus as the institution designated by the United Nations to perform the supervisory function and, on the other hand, the prerogative to sanction that inheres in this function. In the absence of a revocatory power, the Assembly could not substantively monitor the decolonization/self-determination process, of which Palestine is an integral component both as a former mandate and as a self-determination unit under alien subjugation. 3.6.9 It cannot be credibly rejoined that the necessary power to terminate a mandate does exist but resides in the Security Council, and not the General Assembly. On the one hand, such a division of labor of the supervisory function was nowhere envisaged, while on the other, if the Assembly lacks such competence, then so does the Council. It also cannot be contended that unless the UN Charter explicitly allocated a power of termination to it, the Assembly would be acting ultra vires. In case concerning the Northern Cameroons, the ICJ found that the Assembly had the competence to terminate trusteeships, but it did not ground this competence in an explicit allocation of such power in the trusteeship chapters of the UN Charter. Instead, the court grounded it in the general supervisory functions of the General Assembly in the decolonization/self-determination process. March 6, 10. In light of its past pronouncements, Israel would be poorly placed to contest the binding legal power of the General Assembly to terminate the occupation. When the Assembly debated the Partition Resolution 181 in 1947, the political body representing the nascent Jewish state posited that in regard to the future of a territory that did not touch the national sovereignty of the members of the United Nations, but instead was subject to an international trust, only the Assembly was competent to determine the future of the territory, and its decision, therefore, had a binding force. After its creation, Israel described the Partition Resolution as the only internationally valid adjudication on the question of the future government of Palestine. In a Security Council debate, Israeli Representative Abba Eban, gesturing to the Partition Resolution, boasted that Israel possesses the only international birth certificate in a world of unproven virtue, and that this juridical status arises out of the action of the General Assembly. March 6, 11. On the same juridical basis that it issued Israel's birth certificate, the Assembly is empowered to issue simultaneously a death certificate for Israel's occupation and a birth certificate for Palestine. Judge Dillard, in a separate opinion in the Namibia case, noted that precedents exist for the exercise of such power of termination by the Assembly, and pointed in particular to the General Assembly action with respect to the Palestine Mandate. 3.7. The potency of a resolution declaring the Israeli occupation illegal could be fortified if the General Assembly requested, in accordance with Article 96 of the Union Charter, an ICJ advisory opinion responding to the question, "What are the legal consequences of an occupying power's failure to negotiate in good faith on the basis of international law, an end to the occupation?" 3.7.1. The proposed question has been crafted in generic language, along the lines of the question posed to the court in 1996. Is the threat or use of nuclear weapons in any circumstances permitted under international law? If the Assembly requested from the court an opinion specifically on the legal consequences of Israel's failure to negotiate, in good faith on the basis of international law, an end to the occupation, it could touch on the issue of a judicial propriety. That is, an advisory opinion by the court should not be given if it has the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent. The prudent course would be to avoid such a risk, even though the court has only once declined to adjudicate a case due to an implicated party's lack of consent, and even though a compelling brief could be filed supporting a court opinion on a question explicitly naming Israel. 3.7.2. Should the court entertain the proposed question and Israel recycle its preliminary objection in the Wall case, to wit, that a court opinion could impede a political, negotiated solution to the Israeli-Palestinian conflict, this objection would almost certainly gain little traction, not least because the proposed question's very premise is the absence of real negotiations. 3.8. It might still be wondered, what useful purpose would be served by a General Assembly resolution declaring Israel's occupation illegal, even coupled with a complementary ICJ opinion, if an action by the Assembly can be enforced only by a Security Council resolution that, now and for the foreseeable future, will almost certainly not be spared a U.S. veto, while an ICJ advisory opinion is altogether unenforceable? 3.8.1. An assembly resolution compounded by a court opinion would constitute a pair of formidable weapons in the battle to win over public opinion. They would perform the same role, but with potentially greater persuasive power, as the Partition Resolution 181 played in the Zionist struggle for legitimacy and statehood. 3.8.2. Military and political disputes, especially in the world today, Mike Pomerantz observed in the context of the Namibia debate, are never devoid of the dimension of legitimacy as an important component of the conflict. An assembly resolution combined with an ICJ advisory opinion would constitute an important step toward delegitimizing Israel's occupation. 3.8.3. The Finnish delegate exhorted a jaded United Nations to obtain in support of its Namibia resolutions an ICJ advisory opinion. He persuasively argued that it would expose the false front of legality which South African authorities attempt to present to the world, and would thereby help mobilize public opinion, especially in those countries which have the power to influence events in southern Africa in a decisive way. 3.8.4. To highlight the salutary effects of an advisory opinion, Judge Weeramantry, in his magisterial separate opinion in legality of the threat or use of nuclear weapons, harkened back to the Namibia case. The court's decision on the illegality of the apartheid regime had little prospect of compliance by the offending government, but helped create the climate of opinion which dismantled the structure of apartheid. When the law is clear, there is a greater chance of compliance than when it is shrouded in obscurity. Indeed, the joint action by the UN's political and judicial organs in the early 1970s had little direct impact on Namibia's self-determination struggle. It did not attain statehood until some 2 decades later, and only after a massive loss of Namibian life and protracted negotiations. But wouldn't it be perverse to then conclude that the combined efforts of the Assembly and the Court were irrelevant? 3.8.5. Jurist James Crawford, representing in legality of the threat or use of nuclear weapons several South Pacific states devastated by nuclear testing, likewise pointed to the contribution international law could play in achieving a humane outcome. No one is naive enough to suggest that international law is a sovereign antidote to the risks and dangers presented by the threat or use of nuclear weapons. But neither is international law merely a charlady, a femme de ménage called in to clean up after the event is over and all the participants have gone home. It can be part of the solution to the problem. But it can only be part of the solution if it is brought to bear on the problem while it, and we, are still around. For the court to declare that the use or threat of use of nuclear weapons is unlawful in all conceivable circumstances would contribute to a solution to one of our greatest modern problems. Couldn't international law also be part of the solution to another one of our greatest modern problems? And if it is to be brought to bear on this problem, isn't now the time for the international community to act, while Palestine is still around and before it is effaced from the world's map? 4.0 Concluding remarks. 4.1 Deeming it premature to recognize a state of Palestine, James Crawford observed a while back, the essential point is that a process of negotiation towards identified and acceptable ends is still, however precariously, in place. He then posed as the central challenge to change the status quo in favor of a comprehensive settlement accepted by all parties concerned, a situation that seems as remote as ever. 4.2 But what if the process of negotiation is just a facade, if there's no agreement on ends, if a comprehensive settlement accepted by all parties is not just remote but unattainable because, in Judge Dillard's words, the parties are at odds as to the fundamental basis on which the process rests, And if this protracted impasse springs entirely from the occupying power's comprehensive repudiation of international law? For point 3, as it happens, Crawford does address, albeit obliquely, such a contingency. A state, he opined, cannot rely on its own wrongful conduct to avoid the consequences of its international obligations. Isn't this a precise description of the peace process? By refusing to negotiate in good faith on the basis of international law for an end to the occupation, Israel has evaded its dual obligations, to withdraw from occupied Palestinian territory, and, from a legal and moral standpoint, what's most critical, to allow the Palestinian people to exercise, at long last and after so much agony, its right to self-determination. For point 4, it is high time to put an end to a so-called peace process that in reality is an avoidance cum annexation process. States, Judge Jessup said in the Namibia case, are not eternally bound by the old adage, if at first you don't succeed, try again. The moment of truth is once again upon the United Nations, in the Uruguayan delegate's words, to put an end to this struggle between law and arrogance. For point 5, the UN General Assembly can and must declare, finally and conclusively, that the Israeli occupation, not just this or that constituent of it but in its essence and totality, is illegal. A full Israeli withdrawal will no longer be held hostage to an interminable negotiating process, the manifest purpose of which, after decades of trying and trying again, can no longer be in doubt, except to those willfully blind, that purpose being to make the occupation irreversible and to consign to oblivion the people of Palestine. The END thanks for watching the video. Please like, comment and subscribe the Learner's Library.